No, as a course.
Welcome to a session in corporate law. So we're going to look at multiple choice questions. Question number 1, which one of the following is the best definition of ratio decidendi of a case? So there are a lot of terminologies when you get to law that you need to understand. There are terms like ratio decidendi, which is a Latin word which refers to a legal reasoning or principle of law on which the decision is based. So whenever judges are making a decision, they use what we call legal reasoning on which a court decision is based. So ratio decidendi is just a rationale behind the decision, why we're making a particular decision. So it creates a binding precedence. So when you have a different case, they will refer to past records that are a similar case. So that is called ratio decidendi. The other terms that are used in law, like tort. Tort is simply a civil wrong that causes harm, loss, or damage to another person, leading to legal liability. So torts will encompass a number of actions like negligence, defamation. In law, we have terms like a defendant. Who's a defendant? A defendant is a party against whom action has been taken. So if I am suing you, I'm the plaintiff, you are the defendant. So a plaintiff is simply the party bringing legal action or lawsuit against another party. There's also what is called habeas corpus. So these are just some of the terms before I get to go through some of the questions that we have here, so that I may take you like a layman in this course. So we're just looking at the glossary or terminologies of law. So a defendant is simply a person who is sued. A plaintiff is a person who is suing. We have what we call habeas corpus. This is simply a writ that requires a person under arrest or detention to be brought before the court. It's called a writ, or it's called habeas corpus. So simply a written document that requires a person who's under detention to appear before court. So we also have a lien. A lien is a right or interest that a lender has in a borrower's property. So a lien is a legal right or interest that the lender has in the borrower's property. So for instance, if I am your creditor, I lend you some money. So I assume what is called a lien, where I have a right in your personal property until the debt is paid. So if you have a car, for instance, that becomes a legal right I have over that. Okay, so an injunction in law is simply an order that prohibits a part from doing a certain act against them. So when the court puts an injunction, it restricts me from having maybe an action against you. So this is a legal term. All right. So these are some of the terminologies. Then we can get back to our question and answer session. So which one of the following is the best definition of a case? Number 1, which one of the following is the best definition for ratio decidendi of a case? A, reasoning of a court upon which a decision is based. Number 2, the final reasoning of a court which is binding upon parties. Number 5, anything reasonable said by a court in its ruling which doesn't form part of the final decision. Number 6, a reasoned previous decision of a competent court. So which one is the answer of these ones? Okay. Which one is the best reasoning for this?
The answer is C.
answer is A, yeah, ratio decidendi. So ratio
The
decidendi,
answer is what?
A. There is a legal reasoning of a court upon which a decision is based. That is called ratio decidendi. How about what is B? The reasoning of a court which is binding upon the parties. That one is called a holding. A holding is simply the reasoning of a court binding upon the parties. It's called a holding. Then anything reasonable said in court in its ruling, but it doesn't form part of the final ruling, has a special term which is called obiter dictum. You've heard of that term?
No.
Okay, so these are terms that you need to understand. Let me just give you the spelling of each of these ones so that you're able to follow. So besides us knowing what the matter, at least you need to know. So the first answer we just discussed here, ratio decidendi, is simply the reasoning upon which the court has based the decision. It's like the reason for this decision, in short, the Latin term. I'm basing my decision as a judge because of a past precedence. Then the final reasoning that the court holds, which is binding, is called a holding or a verdict. When I make the final decision, that is my holding. When I decide to say this is a final say, it's called a holding. But see, anything reasonable said by the court, but it doesn't form part of the ruling, says no, you should have first apologized to this person because you are married to this person. However, despite you having the obligation to have apologized, your husband is always right. So I've said everything good that could have been said, but it doesn't make a final decision. That is called obiter dictum. These are just sayings that the court may have. Are we together?
Mm-hmm.
Is that clear? All right.
Yes. We're not done.
So, Esther, yeah. All right. Thanks. Okay, so, okay, can send it to me. Then we have reasoned previous decisions that courts may use to make decisions in common law. We call that precedent. So there are times when I'm going to refer to a case that was done by under Manawasa, which had a similar, so it's called past precedent. The terminologies. All right.
Mm-hmm.
So let's go to another but question. I'm trying to amplify than just answering the question so you understand what each of them was. So now is the question: which one of the following best describe obiter dictum case? Okay, I'm just mentioning that. Which one best describe? It is something that is said by the way. All right. So something said by the way doesn't have a holding. So obiter dictum is simply what? Something said by the way. So obiter dictum refers to statements made in a legal opinion that are not essential to the decision in court, therefore are not legally binding. They are just remarks made in passing. You get it, huh?
Mm-hmm.
Yeah. So which one of the following is a direction of thought? Which one of the following is direction of thought? Remember, I mentioned that thought refers to what? Criminal actions that are illegal. So I said thought represents what? A civil wrongdoing or harm that is done to another person, which can lead to legal liability. So these will range from issues of negligence, defamation of character, wrongdoing. Those are under thought. All right. Now the question here is, which one of the following is a direct definition of tort? Number one, right to sue another person for damages. Number two, civil wrongdoing than a claim of breach of contract. C, infringement of interest of a person, which entitles them to a compensation. Number four, civil wrong involving to a claim in a contract. So of these ones, of these ones, which one seems to be correct most? So it's part C, infringement of interests of a person which entitles them to compensation. So for a tort, this is a civil wrong which results in harm or loss, and the injured party is entitled to compensation. So a wrongdoing that you do, okay, like the issue where somebody tries to lie about you, an incident where somebody wants to fake rumors about you under tort, you can sue them and you'll be given compensation. So this is the best definition under tort. Okay, right to sue somebody for damages, these are other acts. So bankruptcy occurs when which of the following is priority? So when bankruptcy occurs, which of these is first priority? Number one, secure creditors. Number two, preferred creditors. Number three, general unsecured creditors. Number four, employees owed. So a company may undergo what is called bankruptcy. Bankruptcy is a situation where a company fails to pay their debt obligations. So the law permits courts to call for a wind-up. A wind-up is an instruction to close the company, collect whatever assets the company has, and now pay the people who caused that company to wind up. And so the first people that are considered are the secured creditors, not even the employees, those who are secured, because they have given the company under a term called secured, so they're the first ones to be paid. All right. So yeah. So now the question also comes in who are the others? Who are the others? So we have secured creditors. First of all, they hold the first claim when assets are being wound up. So when there's a default, secured creditors have the right to seize or sell the collateral to recover them. Then we also have fair creditors. These are a specific class of creditors. In the event of liquidation, they have a higher claim on the debtor's assets than secured creditors. Yeah, they're more preferred than the unsecured. So there's secured and unsecured. So after these ones, we got the preferred creditors. They're given first. Then we have the general unsecured creditors. These are creditors who do not have a specific security that they can hold on each or hold on to the no. These are just general creditors. Then we also have employees owed wages. These are individuals who have worked for a company, but maybe they missed months that they were not paid. They are paid after the unsecured creditors are settled. So this is the order that we use. Okay. So 1.5, which one of the following is not an element of a tort? Which one of the following is not an element of a tort? Number one, an act of omission on the defendant. Number two, infringement of the interest of the plaintiff. Number three, infringement which the law recognizes as actionable. Number four, the plaintiff proving beyond reasonable doubt that their vision of facts are more believable. So D is not an element of tort, because usually tort cases are based on the balance of probabilities, not on reasonable doubt in criminal cases. So all these A, B, and C qualify, but D, because of the aspect of what? Believable facts. One 1.6, which one of the following is not an essential prerequisite for all contracts? Which one of the following is not prerequisites of all enforceable contracts. So the question is, what are the prerequisites of an enforceable contract? So a contract must have offer, so we're now on question number 1.6. So question reads, which one of the following is not an essential prerequisite for all contracts? Parties must have capacity to contract. Parties must have consent to the contract. Parties must have purpose of the contract. The purpose of the contract must be legal. Then the contract must be in written form. So which one of the following is not a prerequisite? So our answer is the contract must not always be written. Okay, it can have a verbal but binding contract. So parties must have capacity is a legal ability that the people involved in the contract must be of age. If one person is below a particular age, the contract is void. You must also have mental competence. So if somebody is mad, you can't enforce that contract. They must also have the freedom from undue influence. If a person was under undue influence where you're putting them under gunpoint in a state where they cannot make decisions, so that the parties will not, the contract may not be enforceable. Parties must have a mental capacity to understand the nature of the contract and its consequences. The second one, parties must consent to the contract, is true because consent is a very critical element in valid contracts. To consent, meaning both parties must be willing, they must be voluntarily in the contract. So this is very essential because the genuine offer and acceptance must be free from fraud and misrepresentation. There must be consent. Contract must be legal. Yes, a contract must be legal. It's valid because you cannot engage in an immoral or an illegal contract. This one is void and unenforceable. What examples of illegal contract would you have where you are paying somebody to enter a job in the civil service? That's corruption. So you cannot sue that person because both of you will be locked up because that is an illegal contract. So the law will not hold the agreements there. Then the last one, the contract must be written. So a written contract is not a prerequisite. Some contracts are verbal, while others are written. Of course, written contracts last longer. So that is how I can explain to dismantle each of these ones. Is that clear? Then we go to 1.7. Which one of the following best describes an agreement in the context of a contract law? Which one of the following descriptions of an agreement, which one of the following best describes an agreement in the context of contract law? Okay. So A, something of value passing from one party to another in return for a promise to do something. B, an offer by one party to accept, an offer by one party to accept another. C, parties must intend their purposes, their promises, and create legally enforceable obligations. Then part C, none of the above. But which one? From explanation, from your understanding, which one is it? Okay, let me expand on each of them. Part A, something of value passing from one party to another in return to something. So this statement simply talks about consideration. That is consideration, which is an essential element of a contract. So consideration is something of value, like money, goods, and promises. So whenever you exchange between parties, it's a bargain. So it is a distinguishing aspect that is valid. It's different from a gift. So consideration is in the context of a contract is valid. So which one of the following best describes an agreement in the context of a contract? So A is correct. B, an offer by one party and acceptance by the other. So this statement describes the process of forming a contract through offer and acceptance. So an offer is a clear and definite proposal, which is given by one person who's called the offerer to enter into a contract. And acceptance by the offeree. This is an aspect of a contract. So B is still correct and A are correct. C, parties must intend that the promises create legally enforceable obligations. So this statement it captures the requirement of legal intent. So for a contract to be valid, both parties must have an intention to create a legal relation, number one. Number two, it should indicate that they understand the legal consequences of their agreement. It can be a social or a domestic agreement. And they're none of the above. So this is an incorrect option. Each of the statements A, B, and C reflect an important part of contract law. So D does not give an accurate answer. So in this context, our answer is which of the following best describes the agreement in the context of contract law? So C. So C, parties must intend that their promises create a legally enforceable obligation. So all these three are valid, but the most valid is C, where as you're entering, you must understand that it's the legal implications that are there. 1.8, in employment law, which of these is not a prohibited ground for discrimination? In employment law, which one of these is not a prohibited ground for discrimination? Race, politics, sexuality, redundancy. Okay. So which one, in short, does not give ground for you to, which one, in short, exonerates you that you can discriminate somebody over them? So which one of these ones is not a prohibited ground? So where are you allowed to discriminate on each of these ones here? In short, which of these provisions are not provided by the law? Let's look at race. Race is protected in the employment law. We're discriminating somebody because of the race is prohibited. So employees here can be sued for unfair treatment because you are black or white. Political orientation. In many jurisdictions, being politically oriented is not considered to be protection because you're UPND, NPF. It used to happen there. As long as, in fact, politics are not allowed in most places. So it's not provided for. So employment discrimination laws focus on protecting individuals from discrimination on attributes of race, gender, religion, disability, but not political affiliations. Sexuality, yes, it is provided for. There are laws that protect discrimination, especially against women. So, and now the gay rights that are coming, there are laws that are protecting them. Redundancy is not prohibited on the grounds of discrimination. So redundancy occurs when a job is eliminated due to business trends restructuring, or other legitimate reasons unrelated to a person's career. So it is not a form of discrimination, but rather a workforce management. So among these options given, being politically oriented is not a considered prohibited ground for discrimination. Also, I must add to say there is no specific law that gives jurisdiction on political affiliations. So the answer there rightly would be B. 1.9. In general, under the Sale of Goods Act, the purchaser becomes responsible for the risk of loss or damaged goods that have been purchased. So the purchaser makes a contract with the vendor, even if the vendor still has something to do with the goods into a deliverable state. So I repeat, under the Sale of Goods Act, a purchaser becomes responsible for the risk or loss of goods that he has purchased when A, the purchaser makes a contract with the vendor, even if the vendor still has goods, but B, if the purchaser notifies the vendor, he's ready to receive the delivery, but C, if the purchaser receives delivery, then D, the passing of property has occurred. So firstly, you need to understand what really happens or what the Sale of Goods Act provides for. So the Sale of Goods Act is provided for to protecting the sellers and the buyers of particular goods that are either in transit or that have been delivered or not yet delivered under different circumstances. So just to define the Sale of Goods Act, the layman is a piece of legislation that exists in various jurisdictions. It specifies between countries how the goods must be treated. So the Sale of Goods Act, depending on the question that has been given, simply governs the sale of goods, the purchases of goods, and also outlines the rights and obligations of both the buyers and sellers. So here are some of the provisions that the Sale of Goods Act may have. Number one, it includes the implied conditions or warranties of the goods. So in the Act, when you read it closely, it will include implied conditions and warranties that a good must be in satisfactory condition. So when you're buying something online and the picture that you are seeing is different from what you get under the Sale of Goods Act, eBay, Amazon, you have the rights to sue because the quality that is purported, that's being showed must, and the purpose for which it was created must correspond with the actual. The Sale of Goods Act also provides for the passing of property and the risk. So in this act, there are rules that are being provided for on the property in terms of the goods as they pass from the seller to the buyers. It provides on who bears the risk at what stage. If I am selling something to Zimbabwe and I'm taking the goods to the station, who bears the risk? Is the transporter or me between my home and the station? Apart from the station to Zimbabwe, who bears the risk? So it gives provisions on who bears what risk. Also, the Sale of Goods Act looks at what? The title. So there are 6 key elements that the Sale of Goods Act must really provide for. So let's go through them. What are they? Number one, the implied condition of the goods and the warranties. So the condition must be reported, there must be a warrant. Number two, the Sale of Goods Act also provides for the passing of property and risk. Who bears a risk of loss between the parties. It also talks about title, the transfer of ownership. So the act also provides who bears title at what point, ensuring that the seller has a right to sell goods and also the buyer has a right to clear the goods in his own name. So when you're buying a car from Dubai, China, it usually comes in the name of the shipping company until it reaches a border where the name now changes to you, because now you have full responsibility. The Sale of Goods Act also gives remedies of breach. It provides what must be done to the party that breaches a contract, including the right to reject non-conforming goods. So eBay has a number of goods that they sell that are called eBay returns. Sometimes when both parties are not liable and the transporting company is the one that is liable, eBay will sell them to would-be clients at a very giveaway price. The Sale of Goods Act also has conditions and warranties of sale. So it differentiates between the conditions that are fundamental and the warranties that are auxiliary in the contract. And also performance and delivery. So these are some of the components that you must know under the Sale of Goods Act. Now, we go to the question here. In general, under the Sale of Goods Act, the purchaser becomes responsible for the risk of loss or damage of goods he purchased when A, the purchaser makes a contract with the vendor, even if the vendor still has something to do with the goods. This is not true. B, the purchaser notifies the vendor is ready to receive. So does the purchaser become liable when you get told, okay, if you pay for your fidelisa? No. C, when the purchaser receives the delivery, yes, you become liable. So if I'm receiving goods now from Intercity to my place and it gets damaged, maybe in the taxi, I become responsible. Also, D, the passing of property has occurred. No, so necessarily it is when the purchaser receives delivery, because the risk of loss of goods typically transfers on the purchaser upon delivery. Once they reach on you and they're okay, then the risk is now on you. Finally, when an agency relationship is ratified, which of the following is not true? A, acceptance by the principal may be implied by the principal behavior. B, ratification may occur within a reasonable time after creation of the contract. Part C, the principal may accept only part of the agreement. And part D, all of the above is true. So the answer is C, the principal may accept only part of the agreement. In a ratified agency relationship, the principal generally accepts the entire agreement, not part of it. So which one is not true? Part C, where part of the agreement is accepted. So I'll explain the agency relationship in depth. For now, just need us to understand the concept.
Sorry.